I don't want you to waste your time. Let's see what we need to do on your case.
Yeah.
Yes, of course.
This isn't a termination and adoption.
What is it?
The termination and adoption.
Okay.
Petitioner, the petitioners are great aunt and uncle of the
Okay.
children. They got the children through a CPS case. Mom is still a possessory conservator. He hasn't been having access. I was appointed amicus.
Okay.
They have filed a motion for continuance, the petitioners have. I'm not opposed to it. I'm actually in agreement with it. They have 2 witnesses that are in the hospital or under the weather and cannot be here next Monday. And I have not been able to reach out and get a hold of respondent mother.
Yeah.
And I really feel like I need to talk to her before this. It's been
I
about.
mean, isn't that kind of telling though that she's not coming?
It is. And she may not know, I don't know if she knew about this pretrial setting or the new local rule unless she was emailed it, but yeah.
Do you mind, don't need to ask you to be a go-between, but do you mind going down and asking Linda what knowledge she has of this case or these attorneys?
Sure.
What she's heard, somebody said it, all of those things.
Okay.
And let's see, I mean, one of the things that I don't wonder is if we still don't keep it set for next week.
Because she may appear knowing to be here Monday.
That could be, and you know, whether that means it goes to trial.
Right.
I don't know, but to not take it off the docket so that we have interaction with people, including could help you.
Yes.
Someone who might not answer the phone for you might be here for court. So if you don't mind going and checking, and let's just see where it is.
Okay.
I mean, because it sounds.
And you just want me to see
how old are the children?
1st grade and 3rd grade.
Yeah, we need to take care of this, or it's just going to set through Christmas. And,
it's been going on for a while. I think we were set some months ago. You just want me to see with Linda then.
Kind of what's going on with the
docket on
the attorneys on it, and if she's heard from Mendieta.
Okay.
If Mendieta received notice.
Okay.
And
of this pretrial. Okay.
I mean, it's not surprising you're kind of running the show here in these kind of cases, right? But that's why we asked you to be amicus, and we appreciate it.
Thank you, Judge.
Thank you.
I'll be back.
Okay.
I'm sorry to interrupt, Judge. I just escaped my. It's been a pleasure knowing you.
It has been. Thank you, Mr. Crowder. Thank you for coming back. Thank you for all you do for the defendants here in our county.
Thank you.
Appreciate you. How are you? Yes.
We're just thinking something to next year. It's just,
Why are we doing that?
we haven't got to mediation yet. We took our mediation date down for a prior hearing and we never got it. So we're back
You
to
have
that.
the file on Cop Enterprises versus Mary Gonzalez. Okay, let me get my notes on it, and then we'll get you right back up.
We had a bench trial in September. They filed a jury demand 3 days before that, and we got this trial setting. That's our procedural history for this setting. It's the first jury setting.
Let me see what I wrote down.
Okay.
I'll get you right back up as soon as she gets it. It won't take her long. How are y'all today? Good. All right. Jack, come on up. Looking sharp today. Good to see you.
See you too.
How are things going?
Great.
Good.
How are you?
Good. So what we're doing today is this is the docket day, which means that all of these cases that I called out earlier are set. These are the defendants. This is their attorneys are listed. They have on this one. This tells that they're in jail or in custody. So, you know, I called out a lot of people that didn't respond. They're in jail, but we want to see if the attorneys are here. And so this is, you know, most cases don't end in a trial. They end in what begins during this process, where the state, that's the 3 people right there, they represent the state. They are meeting with the attorneys as they come in today and negotiating. You know, they'll make offers, a plea offer, The attorneys will go and take it to their clients and discuss it with them. Then they'll come back and say, okay, we need more time, or we've got a deal. The state will put together paperwork, which I hope. State, do we have any paperwork coming or any pleas coming?
The defense counsel is working on something.
Okay, so y'all pass some out.
Yes.
Okay, so we may take a plea very shortly. That means they've reached an agreement with the defense and the defendant on a case. And now what will happen is they'll come up and they'll do the plea agreement here. So everyone has the right to a trial. Defendants have the right to a trial. The exception is if they want to waive all of those rights and enter into a plea agreement. And so I think shortly we'll have someone who will do that. And you'll get to see what it is that when we go through that process, because it's interesting. It's all his or her constitutional rights. We lay out for them and see if they really want to enter into a plea agreement. And if they do, then we have information. We take it. It's interesting.
Yeah.
So what do you see so far?
I think it's really interesting.
Yeah.
But, there's a lot of formalities too, and even though there are formalities, it's still casual, welcoming.
Yeah, well, good. Well, let me take care of a few more. If you want, so you're even closer. We can put you right here in the witness seat,
Oh, okay.
in the witness chair, and you can see what's happening next.
Thank you so
All right,
much.
yeah, glad to have you. The docket sheet.
Okay.
Okay, she has someone coming up. Donkey at 10. I think we have a whole set of students coming in. Yeah. From a leadership institute for San Marcos, and let's put them all in the jury box. Do you have the file on? Miss McNutt's case? You don't have that one either? Okay.
The other one.
For which one?
For the other one for the second case.
Okay. Can we get all of them that are set today? And now you do have the Cobb Enterprises? One moment, I need to take care of one case.
Sure.
He's been sitting there waiting patiently. Ms. Springfield, you want to come on up? Okay. Motion doesn't meet the requirements. I'll tell the reasons that I need to,
Reasons are we've not gone to mediation yet.
not here.
I didn't think I needed to if we agreed on it.
Not yet. You do, because it takes 3 to agree, but that includes the court. This case needs to be moved forward.
Would you like me to file a minute? I can now reach the office. It's gonna say we're in mediation. And when we lost our mediation date back on October the 30th, Ben and I talked about moving this thing. And it's not done a little bit of work. We didn't think we could get everything done in the timeline, so we kind of just put our hands down for a bit. We're just looking for March, you know.
You're not gonna get it in March. Okay? This case gets done, it's gonna get done next week. You're gonna sit on it forever. So. um, It's not. You guys are good, you ordered, you know your case, you can try it.
You're okay if we don't go to mediation and we try to settle this thing?
I think y'all should be talking to each other over the week. I think it should settle, but we're gonna move it forward and something will happen. Either it'll be done by the end of the week, whether it's because y'all agree, whether you have mediation in the next few days, and you can find someone who's ready to talk to you.
How big is the docket for the trial docket next Monday?
Well, because no one seems to want to show up today, it's very slim.
Okay.
And I thought this would be the trial, so
Okay.
this is one that,
Can I ask you a question?
Yes.
Do you want to try it?
yeah.
Okay.
I mean,
Okay.
look, if it needs to be tried, it needs to be tried. It's,
There are cases and judges want to try cases that don't want to.
I want to, I would be happy to have two good attorneys who've always come in here and proven to be prepared and ready. I'm not sure that this is one that you guys want to go to trial, and I'm not pushing you to go to trial for me wanting good attorneys, but y'all should be talking, right? I mean, we know, I mean, I know what I think is going to come down on this case. You need to have your, it's Ben, right?
Yeah.
Okay.
I'm gonna call him, I'm gonna text him on the way out here, because I didn't expect any opposition to it.
No, it's how we get things done. Yeah, yes. I remember what we're talking about here is y'all should mediate, but we had, I mean, since the last setting,
I think shortly after that setting, he and I talked about moving it, but it was better sign on our hand because we anticipate pushing down the road for 90 days.
that's what happens. And it's not. Yeah. So, all right, I look forward to it. You guys let me know if anything changes. Oh, I know what I was gonna say. On how long do you think you need to try it?
How big is our panel going to be?
Pretty good.
We'll see the panel by lunchtime.
Yeah.
5 witnesses. If we have we have a panel 9 o'clock on Monday morning.
Yeah, we'll start
We'll give it-
testimony on the afternoon.
We'll give it to them Thursday afternoon.
Thursday afternoon? Okay.
Well, what's for you? What's the trial date? 4 hours testimony, 6 hours testimony? What's the trial date gonna be?
No, 8 hours.
We're gonna work for it. I mean,
We work all day
no,
and
I
we,
mean,
and we
the
move
jury
things.
box.
I mean, except for them coming back and forth, will probably take an hour from them. But
I was just thinking, an
We'll
hour for
be
lunch,
moving.
and a break in the afternoon and a break in the morning, all of a sudden an 8-hour day is now 6 hours. And pragmatically it becomes 5. So I was thinking,
but we move in here.
Okay.
I know we don't sit around and wait on rulings. You get your rulings
appreciate that.
and you'll have your trials.
Okay.
By Friday, I need a
Charge.
charge that you've agreed to. If you don't agree to anything in it, submit one that has in red line what is not agreed.
Okay. Given the fact this is our pre-trial hearing, do you want us to just toss away any motions in limine or approach those or bring those up prior to selection?
I mean, you guys talk about it and find out if there's anything that needs to be taken care of in advance. I mean, you guys both work together very well. I'm sure it will go smoothly. Confer on anything that needs to be taken up before jury selection. I mean, most of those things aren't jury selection issues, but if they, I would prefer to do it at lunch that day because we don't need to waste time if you guys end up sorting this out.
Okay. All right.
All right.
Thanks, Judge.
Thank you. Yep. The one on top is, okay. Or make that, okay. Let me take this one up. Yes, sir. Who do you have?
Julio Martinez is in custody. You may recall that he tested positive for meth or something last time you put him in jail. So the state's agreeable to him pleading open to the court, which he is seriously considering. But he would like some assurance, if he does that, that he would get out on a personal bond pending preparation of PSI. So I thought I'd run that by you ahead of time.
Sure. You can ask and I will consider it.
That's not the answer I was looking for.
I know.
But,
I mean, I'm gonna listen to what the state has to say. I'm gonna listen to what you have to say. I'm gonna listen to what he has to say.
okay, I understand. I'm not-
I know. I mean, if he was out, I could see a world where he would get back out and be on pretrial monitoring before then. But I'm not gonna guarantee anything until I've seen everything.
So could we have that personal bond discussion prior to him pleading guilty before the court?
No, that's not the way it works.
I know that, but
I mean,
Yeah,
I'm
I'm-
trying to see how I could try to help you out. We would only do that. I mean, you can ask for it whenever you want to ask for it. Right, but I don't want to set it up where that decision is what causes him to either take a plea or not take a plea. Right, it's just not, the court doesn't want to use leverage against him. He should be in jail because he's in jail. We'll see where things go.
Okay.
But happy to consider it. It's not my goal to keep people in jail who are clean and aren't going to be testing dirty for methamphetamines, but testing dirty for meth is a big problem because
I get that.
we know it's not something that you can just do occasionally. If you're on meth, you're on meth, and that makes it very hard. I mean, he's had 42 days to clean up. Maybe that will help him. Pretrial services will work with him closely to try to get him some help. So we have a program that I think Hayes County has done a really good job of setting up to help people in exactly this situation. And I use that program as much as possible.
Yeah.
Ask poor pretrial services if I use it much.
I understand.
Okay.
Okay, I'll get back to you on this.
Thank you, Mr. Campbell.
I got you.
All right, what did you find out?
Respondent mom was not noticed of today's hearing.
Okay,
Which means she doesn't even know about the motion for continuance possibly or has her voice today. So I think, Mr. Rodriguez should probably set his motion for continuance for Monday and we just show up on Monday.
okay.
And then maybe we can all, maybe mom shows up, maybe mom doesn't. We can decide what to do with that.
Okay, how are we going to ensure that she has notice for that?
She does have notice for that hearing. That was given to her 45 days ago. She has come to other prior hearings. I've had pretty good communication with her up until about 45 days ago. So, but he did,
Well, that's a long
Petition.
time. Okay, so we're set for trial on Monday. All parties need to know that
Mhm.
and be prepared to go to
Okay.
trial. And I mean, we need to take care of this case. We have children of first grade and third grade. They need to be taken care of and they need to be in a stable home for Christmas.
All right. Thank you, Judge.
Thank you. What's the dot mean, Mary?
That it's an adoption and.
Oh, did you ask how long on that one? How long?
No. We're gonna put y'all in the jury box. We'll put as many as we can in there. We'll put the others on the front.
Those termination cases, if they do terminate, it's an appeal, they give me 10 days to get that record out.
I don't think it's gonna, I'll talk to you about it.
So that's why I was just wondering if they thought.
And put those who can't get in at the end of the front.
There's one more chair over there. There's one chair. With your chair.
Ruby, let me get some. Evans, you have something to take out?
Your Honor, I'm working on Mr. Jerome. I'll let you know when we're ready.
So welcome.
Oh, how are y'all? Good. So you guys are the leaders of San Marcos? Awesome. Yeah, stay is. That's a good thing. We need good leaders here. This is a cool town. It needs people to take care of it. So what age are y'all? 17. So are you seniors? Yes, sir. All seniors. All right. And how do you get into this program? Our school is going to be applied for which is the right process. And then, so what else schools are represented? Right, great. So you're in a felony district court today. We have 6 of those in Hayes County. That means that we hear the felony cases. That is from less than a gram cases of drugs, not marijuana, but the heavier drugs, up to murder cases, aggravated assaults, a lot of unfortunately sexual assaults of children, come from this court, and that's what the matter files on. Today is docket, which means that a lot of people have already left for the day, but we've got a room full of defendants who were sitting there earlier this morning. They come in and wait for their attorneys. When their attorneys arrive, just like Mr. Evans said, this is the state. Okay, these are the prosecutors in the case. So they're the ones who bring the cases against someone for an allegation of an offense. They're saying someone committed a crime, right? They bring the case. Then the defense attorneys, like, while using this one here, they come, they confer, they talk about where they are in the case. Maybe the defense attorney says, I haven't received this kind of evidence. Maybe there's a 911 call, right? There's a lot of 911 calls in these cases. I need a 911 call. Say that goes and waits for the 911 call. Or they say, what is the plea offer? So everyone has the right in the United States to a trial. Right, that's the basic, that the most you get a trial. If you were charged with a crime, the Constitution says you get a trial. But if you want to waive that trial and enter into agreement, we let people do that. So what that's how most cases are taken care of. Right? We can't go to trial. We've got hundreds of cases, and we've only got a week that it might take to try one case. So those things are taken care of right here, where they negotiate. They come through and decide, we'll take this plea offer. Let's say it's a murder case, right? And the range of on a murder case is 5 years to 99 years or life. And the state says, we're going to offer you a civil trial. We're going to offer you 4 years. 4 years. And then so I don't want 4 years, but they come back and say, we'll take 30 years. And so they negotiate. I'm just making up numbers here. I don't know what the negotiations are. I think it's inappropriate. People need to know, because it kind of might indicate something about the case to me that I don't need to be biased in a way, right? I just want to clear the case of what they have. So they'll do their negotiations, and if they come to it, so. Which means they probably have an agreement with somebody, and they're going to give that paperwork that tells what all the defendant's rights are and what he's going to be waiving, and they're going to give it to the defense attorney. He'll go back to the defendant and meet with them and go over all of his rights and what he's waiving and what this means. Everyone has to know exactly what they're getting. And then they come to the court, and I go over it again. We want to make sure everyone knows, and they are knowingly and willingly entering into these plea agreements. Because remember, they're basic, for everyone, it's a trial. So we're just looking at whether they're going to waive those rights. So that's what happens here. So today, most have come in already, taking care of their case. They've made their reset. So we'll have 3 settings of a pre-trial setting. That's just where they'll come in, they'll talk to the attorneys, the defendant comes in. Maybe the defendant will get tested for drugs, or make sure that they're complying with all of the rules because they're out on bond. So today, everyone we've talked to so far are out on bond. So let me tell you what that is. Right? Talk about that. When someone is arrested, then they're in jail. They take them to the jail, and a bond is set. That bond can, let's just say the bond is $5,000. If someone makes the bond, that means they enter into an agreement with usually a bond company. The bond company pays $5,000 to the county. Now, it's not money to get this kept, it's just held. Because the bond is the assurance that the person will show up for court. So all the people that sit out here, that means they're on bond, when they make bond. And when you make bond, you make certain agreements, you're not gonna commit any more crimes, you're not going to be using drugs. You will be following the law, right? And you will show up to court. So that's what the bond does, kind of assure that people come to court. There are all of those who don't make bond. Maybe their bond is very high. Maybe for some reason they don't want to make bond. They don't want to pay any money. And they will be, so we have today maybe 5 or so. So that deputy over there, he has the people who are in downstairs, and they're in a holding cell downstairs. When their attorneys come in, they will come up and bring them up and talk to them. But they can treat them just like the people who are on bond when they're in court, right? They know what's going on in their case. So what all of those that are sitting in here are people on bond, the ones that he has that will come up, and you'll know which ones they are. They come up because they have on the colors of the jail that they're in. Some of ours are in Hayes County Jail, some of them are in the Mountain County Jail, Haskell County, and they may be wearing different color clothes. And then they have different designations, and they don't have different color clothes. So that is what today is. It's really all over. It's not what you see on TV. You know, what we see on TV is the 1% of what happens. That's the trial, right? The 99% of what they're doing today. And so that's what you're seeing. Say where you have to know.
I think we have a couple of pleas out, Judge.
Please.
Yeah, they're bringing up one of the guys right now, so I should have a plea there in a minute or two.
Let's come say hello.
I'll come to them.
I'm finishing up.
Well, this is one of our prosecutors. Introduce yourself, everybody.
Thank you, Melanie. I've been with the Hayes County Attorney's Office for just over 2 years. I started with law school at Baylor, went to school, undergrad, at state New York, or all high school students. So what a good time. How is that? Does everyone interested in law, want to be an attorney, or is there because you have to be?
This is a leadership institute, and so, these are future leaders, some will be lawyers, some will be judges, some will be officers, some will be doctors, maybe everything, right? These are people who will get things done.
So is everyone interested? I'm just very excited to see anything for today, honestly. I'm a judge. I was saying, it's a docket, it's like the nitty gritty kind of stuff that we do every day for most of it's not favorites. But it's also like one longer does the most. And they're, it's at least for a prosecutor, it's what I do, but that's what I'm practicing. But you know, see some of these. Questions or anything like that?
Why did you go to law school?
I went to law school, my dad's an attorney, my sister's an attorney, and so kind of was gonna happen no matter what. But then I became a prosecutor. I decided I was gonna be a prosecutor my first year in law school. I actually witnessed a crime, and then a week later started criminal law and got really inspired by a professor in that class, and I was after just to play law. So that's why some people prosecutor and it's not which is. So you want to be an attorney, you raise your hand. Any idea what kind of law you want to practice?
You ready? Okay.
Yes, it's the right kind of law practice. Everything on
We take a plea. We taking a plea on this one?
Yeah, they just have to make two attorneys.
All right, let me show you, for instance, here's the docket. Docket means like the list of cases that we have today. The defendant, the attorney, the charge, the case, and what setting we're on. This is a punishment setting, possession of a controlled substance, heroin, 1 gram to 4 grams. So that's what we're looking at. They all come in, and I'm making notes, everyone's making notes, but for instance, this case has been reset. It was just on a pre-trial. So I was telling you, there was pre-trial. Well, they do a plea setting, which means they plead, kind of moving forward. And if they don't plead, there's not some resolution, the next setting is a trial setting. We had trial announcements today. We start trial on Monday. We're on Monday. Yeah. Jury, and that is a very interesting thing to pick a jury, because this would be setting to county people from the community, your moms and dads and uncles and grandmas and grandpas will be out there, and we're gonna try to find 12 people to set where you're setting to hear the case. And so that happens on Monday. So I say a few words to them, and then the attorneys get up and ask them questions about the kind of case that we're talking about. You know, can you be fair to this kind of case? Let's say it's a burglary. Would you be fair to burglary case? Well, we're gonna say, why not? Why not? Because it's going to be unfair if you was applying this guy who's an abuse or something. That's not evidence, right? And so that's what we try to do, is really try to get 12 people who will be fair and impartial. That's what this system depends on, right? That they're gonna listen to the evidence. In other countries, what they do is they say, on someone accused of doing something wrong, they throw them in jail, they sit there, and then somebody decides, okay, they're gonna stay in jail for this amount of time. Judge or king, maybe a judge, maybe a judge. What we do in this country, which is amazing, is that we ask 12 people from our community, moms, dads, you're 17, and next year when you're 18, maybe dads come in. We ask you to come in and decide what happens. That's awesome. They don't do that anywhere else. Right? They just throw people in jail. Remember that WNBA basketball player? Ready, Brian? Right? You should sit in jail forever. You should know what you're charged with. There's some trial. We don't do that. We think of democracy, that's, we rule ourselves, we're in charge of ourselves, so really. And we elect people who go to Austin or go to Washington and they totally make decisions in their words. Right, if that's somebody else, if you were on the jury, who makes the decision? One for guilty, 11 for not guilty. One for not guilty. That's 12 people. They deliberated. They like to talk about what said. They made that case. Become or something. It has to be. So the thing, you hear on the news about some case where somebody is found guilty or not guilty, and they get upset. Like right now, people are very upset. Some people are very upset about that happening in New York. There was a guy on the subway who stronghold on the guy who died in his trial. A lot of people are very upset. I don't get that upset. Now, the jury, hey, give me evidence. People who are yelling, that was wrong. Wait a second, our system is set up. So 12 people say, well, you are, and here from right there, that witnessing, they make the decision. And if we have 12 fair and impartial people who believe in our system, like I want you to believe in it, and they come to a verdict. Right. Thank you. Appreciate it. Our wisdom is very people that belong to the right. And if we get fair people that come in and they're willing to say, listen to each other, and their minds. They're getting rid of, they slide. Check. So they strive those who have said something that. Right now, or do you want me to do this? It's not somebody. You're getting people who said, I can prepare. And when they are prepared, they sit here and follow the rules that you put in front of us. They listen to the definitions of the state. It's awesome. We are the only places in the world that do this. That's really cool. We all come be a part of it. It doesn't be any day off. To talk to you, or anyone up here. You come to the attorneys. They're more than willing. We're all willing to help them, especially those who are motivated to talk to us. You guys listen to all of the rights of the thing that we will go over.
Yeah, so you're waiting.
I'm sorry, yeah. Oh, thank you. I appreciate it.
Not on the terrorist support. Violence. But doesn't have his other.
I might be second. First on one. we're kind of, the ones that I expect are kind of. Flores is, which is number one, is 80, which is, I think, what's going to go. Some of the other ones, who knows? Who knows?
All right. You may be seated. All right, what do we have ready? Three, please. Three, please. We'll start with Land Rutledge. Hey, Mr. Rutledge,
Sir,
doing okay today?
I'm doing fine. How about yourself?
Good, thank you. Ruby, are you ready?
I'm ready, sir.
Court call CR 24-2811F, the state of Texas versus Land Davis Rutledge. Can counsel please make their announcements for the record?
Philip Giebert for the state.
Dan Daniels for the defense.
And are you the same Land Davis Rutledge who in CR 24-2811F is charged with theft $2,500 to $30,000?
Yes, sir.
That is a state jail felony. State, what is the range of punishment for a state jail felony?
Not less than 180, not more than 2 years in a state jail facility.
Do you understand that is the range of punishment that you face as charged?
Yes, sir.
All right. Can you raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. I have before me paperwork that indicates you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
On page 4, there are a list of rights that you would be waiving if you enter into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there is a stipulation of evidence. I will use that to determine if there's sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yes, sir.
Sir, this is an agreement between you and the state. I don't have to follow this agreement. But if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen.
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, do you still wish to proceed with this plea agreement?
Yes, sir.
Are you a citizen of the United States?
Yes, sir. I am.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with Article 3914 of the Texas Code of Criminal Procedure. Are you satisfied that the state fulfilled that obligation? And do you believe that Mr. Rutledge is competent to enter into this plea?
He is.
Mr. Rutledge, the reason we talk about the evidence is because you have the right to know what it is in your case. Did you discuss that evidence with your attorney?
Yes, sir.
And are you satisfied that he has provided you with effective assistance during the course of this case?
Yes, sir.
According to your plea bargain agreement, the state will reduce this charge from a state jail felony theft $2,500 to $30,000 to a lesser included of theft $750 to $2,500. Is that correct, state?
Yes, Your Honor.
And that's a misdemeanor violation. State, what's the range of punishment for that?
Not more than a year in the Hays County Jail or a county jail system, and a fine not to exceed $4,000.
Do you understand that's the range of punishment for this lesser included?
Yes, sir.
In exchange for your plea of guilty to that lesser included offense, the state will recommend 365 days in the Hays County Jail. You will get credit for the time that you have served. The state will also dismiss related misdemeanor cases. BOV, what's that?
Burglary of a vehicle.
And a crime.
Criminal mischief.
Criminal mischief. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
Yes, sir.
To the charge of theft, $750 to $2,500. How do you plead?
Guilty.
Are you pleading guilty because you are guilty and for
Yes, sir.
hold on, let me finish. You're pleading guilty because you are guilty
Yes, sir.
and for no other reason.
No reason.
All right. State, have you given notice to the victim in this case of the proposed resolution?
We have, Judge. The co-defendant in this case recently pled out in a different court, and the victim was aware that a similar plea was given to both defendants in his case.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Are we going to do sentencing today?
Yes, Judge.
Yes, sir.
Is there any legal reason we can't proceed to sentencing?
No,
Any argument from the defense?
Nothing.
Anything from state?
just to follow the plea agreement, Your Honor.
Based on finding you guilty for theft, $750 to $2,500. The court sentences you to 365 days in the Hayes County Jail under a Class A misdemeanor. You will get credit for the time that you have served. And when submitted, are you going to submit those dismissals to me or to the misdemeanor court?
Misdemeanor court.
All right. And they will submit those as they told you they would. Is there anything else that we need to take up?
No, Judge.
Nothing for the defense.
Sir, I have followed your plea bargain agreement, and because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification that says that. That will be added to your file. Good luck to you, sir.
Thank you.
Mr. Daniels, can you come up real quick? This will be my last opportunity to say goodbye. Thank you for what you do for defendants. I appreciate knowing you, and I like your fight on things.
Appreciate it. Thank you.
Good luck to you.
Merry Christmas.
Thank you. Merry Christmas to you. Who's next? Stafford. I'm sorry. Yes.
Think we need him.
What's that? Probably gonna need it. Did it fit? Did it fit?
Yeah.
All right. Ruby, are you ready?
Yes, sir.
I think I'm good in the little background. All right, so this is a case that we're going to do today where we went to trial and the state presented its evidence, defense argued against it. In this case, the defendant testified, and after the case, the jury deliberated for 2.5 days and they ended up being hung. That means they were not unanimous, right? So when I tell you that just think about 12 people. If I were to take the 12 of you and ask you to agree where to go to lunch, do you think you would agree? Probably not. When 12 people agree in a case, it's a really incredible thing. And they couldn't in this one, just because the evidence, they didn't think the evidence was there. So now we've come back. When a case is hung or we declare a mistrial, the state case is still pending. And that's what we're here to do today. They've now come back and they're going to take a plea on a separate charge. So that's what you're seeing today. Ruby, are you ready? Is that fair? All right. How you doing, Mr. Stafford? All right, good. Court calls CR 22-0978C, the state of Texas versus Mario Lee Stafford. Can counsel please make their announcements for the record?
Philip Giebert for the state.
Ryan Vickers for the defense, Your Honor.
And are you the same Mario Lee Stafford who in CR 22-0978 is charged with sexual assault?
Yeah.
Okay. Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
The sexual assault is a second-degree felony. State, what is the range of punishment for that charge?
Not less than 2 years, not more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that is the range of punishment that you face for this charge? I have paperwork before me that indicates you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
On page 4, there are a list of your rights that you will be waiving if you enter into this plea bargain agreement. Did you know that you'd be waiving these rights?
Yes, sir.
On page 5, there's a stipulation of evidence. I will use that to determine if there is sufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yes, sir.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow the agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, you still wish to proceed with this plea agreement?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with the Code of Criminal Procedure. Are you satisfied the state fulfilled that obligation?
To my knowledge, yes, they did, Your Honor.
And do you believe that Mr. Stafford is competent to enter into this plea today?
I do, Your Honor, yes.
The reason we discuss evidence is because you have the right to know what the evidence is against you in your case. Did you discuss it with your attorney?
Yes, sir.
And are you satisfied that your attorney has provided you with effective assistance during the course of your case?
Yes, sir.
According to the plea bargain agreement, the state will proceed on a lesser included of indecent assault, a misdemeanor A case. State, what's the range of punishment for a misdemeanor A?
Not more than 1 year in the Hayes County Jail and a fine not to exceed $4,000.
Do you understand that is the range of punishment for that lesser included offense? In exchange for your plea of guilty to that charge, the state will recommend deferred adjudication for 18 months. There will be a fee, an evaluation, community service, TCAR,
Treatment and counseling as recommended.
to have. So what's going to happen is someone from probation is going to make recommendations of certain conditions, and whatever is recommended, you will do. Is that your,
Yes.
is that your understanding of the agreement?
Yes, sir.
You also have an agreement about another case in Walker County. Is that right?
Yes.
As it's laid out here? All right,
It's Waller County Judge.
Yes, it's Waller County.
Waller. Okay, I just misread.
Sorry, my handwriting is not,
I was gonna blame Philip. Oh,
I'll throw myself under the bus.
all right. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
Yes, sir.
To the charge of indecent assault, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
State, have you given notice to the victim of the proposed resolution today?
We have, Judge.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt. What I'm going to do is order a PSI. That means someone from probation will talk to you. You'll get a date for that meeting right now, and then we'll come back at a future date and do your sentencing. Understood?
Yes, Judge. If the only thing that they need to talk about is the treatment and counseling and those conditions, if defense is ready, we are ready to potentially sentence if you want to do that, so that you can finish this case out.
We did have an agreement about the conditions as well.
Yeah, especially the sex offender conditions. And so
What
I
is the
think
agreement on those?
it should have been on there that there's a list of normal conditions when it comes to sex offenses, and we've agreed to the ones that I think it's 27 through 29 and 35 that are going to apply, with the others being struck. And so the other conditions are just going to be general treatment and counseling through probation. And I think that at this point, defense would probably be fine with those. So
I mean, do you want to proceed today or have those subject to a PSI?
Well, Your Honor, since we have such an agreement, I think it's fairly comprehensive. I think the state would agree. If the court would see fit, we could proceed with sentencing today.
yeah,
Okay.
I also think because it's a lesser on a misdemeanor, that there is no there's no need for a PSI. There's no statutory right to it.
I mean, I think whether that is due to the
Sure.
seriousness of the charge, I would want a PSI.
Okay.
I mean, I think it should be done and someone should take a look. So if we do that, then we'll have a status hearing when we can come back.
Just
and the
argue
judge
those,
who is here can review what is presented and adjust accordingly.
Yeah.
Okay, is there any legal reason that we can't proceed to sentencing?
No, Your Honor.
No, Your Honor, there's not.
Having found there was sufficient evidence to substantiate your guilt, I do not find you guilty at this time. Instead, the court grants your application for deferred adjudication. That will run for 18 months. You will have a $60 community supervision fee. You will do the evaluation. You will do community service hours of 100, and you will do the sex offender conditions 27 through 29 and 35 of the usual sex offender conditions. The state will dismiss another misdemeanor. Is there anything else that needs to be taken up on that?
Your Honor, if I could just clarify, just for the record, the conditions that are imposed for the sex offender requirements are not those of registration. Just so
Correct.
the court is aware, so you would not be required to register under this plea. And we'd ask to be heard on indigency if the court would allow.
Okay.
May I proceed on that,
You may.
Judge? Mr. Stafford, could you tell the court how you're currently employed?
Yeah, I'm working for like Uber, like the Uber and I do no Amazon work.
Do you receive a steady paycheck or is that pay as you needed?
Pay as you need to know, like pay as what you work.
Okay. How much do you currently make a week and a month?
Week, maybe just say like $500 a month, just say 2,000.
Okay.
Yeah.
Would some of the court costs and attorney's fees cause an undue financial burden on you at this time?
Yes, it will.
Okay. Are you asking the court to find you indigent for the purposes of the court costs and attorney's fees in this case?
What are your, we'll state first, do you have any cross?
No, Judge.
What are your expenses right now?
I got a newborn baby coming in a month. And I'm
You're gonna have a baby in a month?
Yes,
Oh,
yes, it's a girl.
okay, congratulations.
That's one of them.
How many children do you have?
I got two. I got one son that's 12.
12?
Newborn baby.
And the newborn, okay. And so what are your
And
expenses?
then, managing on, like where I stay at, eating, phone, stuff like that. So managing child support, because I am on child support for the first child.
Can you give them a number
$300 a month.
for the child support?
Yeah.
How about for rent, the car and the?
Rent, I'm paying $100 to my room at the moment, you know what I'm saying? And then my phone is $65 a month.
Okay, we'll waive the attorney's fees.
Thank you.
How much will court costs be here? You wanna know what attorney's fees would be? I mean, I say court costs. Okay,
Would it be imposed at the misdemeanor level, Judge? Is that what the court cost would be, or would it be for the district?
I would think it's for district court.
Just-
So we're gonna waive the attorney's fees. You do need to pay the court costs, okay? But I want you to be responsible for what we've all done here
Yes, sir.
today, all right? Is there anything else we need to take out?
No, Your Honor.
Nothing at this time, Judge.
Sir, I followed your plea bargain agreement. Because I followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will be added to your file. Good luck to you, sir.
Mr. Secretary. Oh, great.
Number.
Right, up and down.
That all for you?
Yes, sir.
All right, it's been a pleasure.
Yes, sir.
Thank you very much.
I
Good luck to
appreciate
you.
you. Thank you.
Oh.
You as
Appreciate
well.
what you do for people. It was
Thanks,
a good
Judge.
trial. You guys were both good to each other. Appreciated it. How are you, Mr. Jones?
All right, Judge. We have Mr. Anselin for sentencing.
Okay.
He's up.
Mr. Anselon, come on up. Good, sir. Good. How many days have you been in jail?
Almost 4 months.
4 months? You look clean now.
Sir.
You feel better?
Yes, sir. Gave my heart to God. I'm not good.
I'm sorry?
Gave my heart to God.
Yeah, you have. Good. What happened?
Just gotta change my ways and
Do,
it's just what I gotta do.
yeah,
You have a grandchild on the way, right?
Yeah, my granddaughter's coming and I have another one.
a granddaughter.
Yes, sir.
Well, you look a lot younger now, you're clean,
Yes, sir.
so that's, well, good for you. Well, you need to take care of them.
Yes, and I have 5 kids, so.
5 kids too.
Yes, sir. They all need me.
Yeah, well, what's, everyone reaches their point. I hope this was actually yours,
It is.
but it's gonna be hard because these drugs, what was your drug of choice?
When I was doing drugs, it was heroin.
Heroin? Yeah, it's really hard, right? Did you have to kick it in jail?
Get in jail several times. And this time I actually quit before I got locked up. I went to rehab and they put me on some Suboxone. Because I think the same thing. I mean, you know, I was trying to stop and they gave me that, but my only shot is getting myself a guy.
Yeah, well, great. That's right. You have to replace that.
Yeah, that's the only thing I haven't done, and this time I have, and it seems like it's gonna be fun.
Good. Man, I'm happy to hear it.
Yes, sir.
You have, can I give you back my docket sheet? So what we're doing now is that this, was it not in that last file? Okay. Is this defendant had taken a plea earlier, and then we came back and the probation office does a report. And based on that report, we know the terms that the person needs so they can be successful. When someone goes on probation, we want them to be successful. So we're looking at what are the sorts of programs that we can put them in where they will succeed. And that's what we're going to do today. All right, ready, Ruby?
Yes, sir.
Court calls CR 22-4283A, the state of Texas versus Stephen Joseph Anzalone. Can counsel please make their announcements for the record?
Allison Boost for the state.
Richard Jones for the defense, Your Honor.
And are you the same Stephen Joseph Anzalone who in CR 22-4283A is charged with possession of a controlled substance, heroin, 1 gram or more, but less than 4 grams?
Sure.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Sure.
All right, we're here today on your sentencing. I've received a pre-sentence investigation report from probation. Counsel, have you had the opportunity to review that report and discuss it with your client?
I have, Your Honor.
Are there any corrections or modifications to the report?
Not to the actual report. We just want to discuss some of the possible conditions, Your Honor.
Very good. Is there any legal reason we can't proceed to sentencing?
No, Your Honor.
State, any argument?
Your Honor, the state's in agreement with probation's finding that based on his extensive criminal history, the number of opportunities he's been given before, the fact that he's been unsuccessful on multiple supervisions, and the fact that he bond forfeited while on bond for this case, that TDC is the most appropriate sentence.
Sense?
Your Honor, we're asking for probation. You've heard my client speak to you. He's at a point in his life where he's got another grandbaby on the way. He's tired of being in and out and stuff like this. If I may ask him a couple of questions, Your Honor.
Okay, you're under oath.
Right. Mr. Anzalone, if the courts put you on probation, do you have a place to live? And where's that at?
Atascosa County.
I'm sorry?
Atascosa County?
Okay. And do you have a couple of jobs lined up?
Yes, I still have my job when I get out.
Okay. And what kind of work is that?
It's a mechanic.
Right. And so I think you've told the judge before that your life has changed since what it was before. Is that correct?
Yes,
All right. And you've got the job, you got a place to live, and you're ready to be successful if the judge gives you the opportunity. Is that correct? I don't have anything else, Your Honor.
State?
No questions.
All right. You heard the state. They think you should go to prison. The probation, those who would be looking after you think you should go to probation. What's different this time that I'm not going to look like, why did I give this guy a chance?
Yeah, I don't know, I just had to, this is enough. Enough is enough. I got kids to take care of. I got grandbabies now before I didn't, before I was younger.
How old are you?
46. And when I did get out of prison, I did finish my parole. I got my certificate. It's kind of different. I give my heart to God. That's the only thing I didn't do before.
Are you doing NA or AA classes?
And yeah,
How often?
it's only once a week.
That's all they have it?
Yeah, that's all that. When I get out, I can go to all of them. It's all I have in here, and they have the chaplain comes once a week.
All right. I mean, what's your case for why you should not be given straight prison?
Prison, when I was in prison, you don't really no classes in there. I just, prison.
Well, it's not just that, but you also told me before, isn't it,
Well, I'm in-
that you weren't getting help, and you feel like if you're on probation, that you're gonna be getting that help and stuff like this. Is that
Yes.
correct?
Yes.
And that prison was just leading to those, continuing those bad behaviors. Is that correct?
Definitely.
All right. Any legal reason we can't sentence at this time?
No, Your Honor.
State,
Nothing for the state.
having found, is he enhanced too? Is this 2 to 20?
Do you have the indictment, Judge?
Well, I have in the stipulations, there's an enhancement paragraph for a prior trip. The indictment, I assume, has it too.
That it should have been a plea of true on the enhancement, I believe.
Okay. I don't show that I took it down at that time, so let's do it now. There's an enhancement paragraph attached to this indictment, and it was part of the stipulations. But let me ask you now, if you're going to plead true or not true to that enhancement. That on the 30th day of April 2010 in the 399th District Court for Bexar County, Texas, you were convicted under cause number 2007 CR 5378 of the felony offense of possession of a controlled substance, a third-degree felony. Is that true or not true?
Yes, sir.
Okay. Court finds that it's true. Previously, I found there was sufficient evidence to substantiate your guilt, but I did not find you guilty. I find you guilty now and sentence you to 8 years in the Texas Department of Criminal Justice. That will be suspended for 8 years. You will have a zero tolerance probation. That means you're getting the chance, right? It's completely up to you. You hold the keys to
8
whether
years
you.
probation.
What's that?
8 years probation.
That's right. You get the keys of whether you go to
8
jail.
years probated for
8.
8 for 8. Okay. Sorry, I just want to make sure I had the judgment right.
You will do NA and AA at least 3 times per week.
Yes, sir.
You have a place to go for that?
Yes, sir.
And if you're not showing, I mean, if you're not doing that 3 times per week,
There's
then
no.
it's a violation, right? You understand zero
Yes, sir.
tolerance? You will be tested frequently and randomly.
Yes, sir.
You will do an intensive outpatient course. I am ordering the ISF program for you for drug abuse. If but I'm holding that in abeyance. All right, again, you hold the key to whether you go to that program.
Yes, sir.
Have you been to it before?
No, I've been to ISF for parole back in 2010. I think it
How-
was 12, but it was for parole.
How is it?
It's same thing as going to prison.
Okay, did you learn anything?
Not to stay out of jail. You're right, but so I'm saying this time's.
Okay, well, I'm holding that in abeyance,
Yes, sir.
right? You make the decision on whether you get it. Is there restitution in this case?
I would have to check to see if there's restitution for testing, Judge. If
Okay.
there is, I'll provide the court with a restitution
Okay.
order.
Restitution for testing, the moral recognition therapy course.
Is there a fine, Judge?
So what kind of job are you gonna have when you get out?
I'm a mechanic for People's Express.
You're gonna make, what kind of money are you gonna make?
You made like $600-700 a week before.
Okay. There'll be $1,000 fine. You will do 400 community service hours. Do you have your diploma?
I have my GD, sir.
Okay, good. And sounds like you need to take a parenting class, all right, and a grandparenting class.
Yes, sir. I do.
Do they have those?
I mean, I gotta get myself involved with that or whatever I can do, sir.
That's right. Let's try to find those if we can. All right. It's your choice now,
Yes, sir.
right? Sounds like you found something, a way to replace
Yes, sir.
the triggers and the darkness
Yes, sir.
with something that's the light, and that's the way to do it. Stick to that.
Yes, sir.
Keep going your NA and AA. I hope you're gonna be very successful.
Yes, sir.
All right. Anything else we need to take up?
Not from the defense, Your Honor.
Nothing from the state, Judge.
Sir, I followed your plea bargain agreement. Because I followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will be added to your file. Good luck to you.
Yes, sir. You have a good day, sir.
Oh.
You too.
Let me borrow your right thumb real quick. Straight up, straight down on the pad, and then straight up, straight down in the box. There you go.
Look at you swear. I think that's all I have, Judge. Maybe excuse.
Yes. Thank you, Mr. Jones. Enjoyed it. Good to know you. Thanks for your help. Go out of here. All right. Thank you all for coming. You're welcome to come back to court anytime. It's your court. Thank y'all. Paige. We had said something to Paige that they were gonna get a picture in front of the, or they can do that if they want. You can ask her.
Yeah, but you're going to wait a second.
Waive attorney's fees on that one. Talk it down there with you. Thank you. Sorry. No, that's not. That goes to them. For this. Thank you. All right. What do you have, Mr. Campbell? Oh, thank you. I appreciate it. Well, thank you all for coming in. Yeah, I hope it was helpful. We said to Paige that she wanted to take if you wanted to take a picture with the flags and the seal, you're welcome to come back in and do it. Okay? Yep. Okay, you're welcome. Y'all have a good day. Thank you. Thank you for what you do for setting this up for the students.
Absolutely.
All right. Yes, ma'am.
Back again on Julio Martinez, he's not ready to do an open plea at this time, and he wants a reset to possibly bond out. He also wants to talk to the court about a new attorney. Apparently my magic wand is not.
Okay.
good enough for him.
Well, let's bring him up and have that discussion.
Okay.
Okay. He's not up here, is he?
No.
Okay. Get him up.
Julio Martinez.
Hello, how are you? Good, nice to see you.
Vacation, I can visit you.
What's that?
On vacation.
Oh, well, lucky me.
Yeah, Mr. Granados.
Mr. Granados, come on up.
We're going to be doing a plea with a cat when you reset PSI.
Very good.
And regarding the competence, et cetera, Your Honor, we have the 2 reports on competence and sanity, and I would just ask that you take judicial notice of those and leave an agreement on their findings. Is that correct?
That's correct.
Competent and sane. I don't know if we need that formal finding last week.
I mean, we talked about this important point, didn't we? And you were gonna have something good in your pocket today. It's the last time I'm gonna see you. What happened?
Well, they stopped selling Kit Kat bars.
What did Kit Kat bars have to do with it?
Yeah, give me a break.
No. All right. But on the inside of those, is that how it tells you how to fold, or how did you know how to fold?
Oh, on the other ones?
You were gonna have a
What
little,
was that fold up nice?
yeah,
Oh,
that's what I thought we were gonna have, like something,
folded up nicely.
yeah.
Yes.
Well,
Well, I thought you might like this color. I was thinking really
what
hard.
color is it? I'm colorblind, so I'm not
Red.
gonna like it too
Red.
much. Oh, it's red? Okay,
Well, I'm sorry about the folded part.
that's all right. You don't need to be sorry. All right, are we ready? Court calls CR 5642 F, the state of Texas versus Manuel Granados. Can council please make their announcements for the record?
Molly Smith for the state.
Victoria Brown for defendant.
And are you the same Manuel Granados who in CR 5642 F is charged with evading arrest with a previous conviction?
Yes,
That is a state jail felony. A state, what is the range of punishment for that charge?
Not less than 180 days and not more than 2 years in the state jail facility.
Do you understand that that is the range of punishment for that offense?
yes,
In addition, there are 2 enhancement paragraphs. State, what does that take the range of punishment to?
It was up to a second-degree felony, Judge.
And what is the range of punishment for a second-degree felony?
Not less than 2 and not more than 20 years in TDC and a fine of up to $10,000.
Do you understand that's the range of punishment you face for this entire indictment?
yes,
You raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
yes,
I have paperwork before me that indicates you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
yes, Judge.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes,
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
yes,
And is this your signature on the final page?
yes,
Sir, this is an agreement between you and the state. I do not have to follow this agreement, but if I don't, I'll allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
understood.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes,
Understanding them, do you still wish to proceed with this plea agreement?
yes,
Are you a citizen of the United States?
yes,
If not, a plea in a case like this could have serious consequences. Counsel, I have the discovery compliance statement regarding the state's duty to give you evidence in accordance with the Code of Criminal Procedure. Are you satisfied that the state fulfilled that obligation?
I am, Your Honor.
And do you believe that your client is competent to enter into this plea today?
I do, and that is based upon the findings of Dr. Maurer in the report provided to the court.
Okay, we have looked at the question of competency before, and the court has now received 2 reports from the doctor on that issue. Both have found him competent. Is that correct?
They have, yes,
Is there any objection to that finding
not from the defense, Your Honor.
from the state?
Not from the state.
All right. In addition, was there a question put before the judge, before the doctor regarding sanity?
Yes, Dr. Mercer Morrow evaluated for sanity at the time of the offense as well.
And I understand that returned with a finding that there was no insanity at the time of the offense.
That is correct.
All right. With all of that from the doctors and your interactions with Mr. Granados, do you believe he is competent to enter into this plea today?
I do believe he's competent and comfortable with this plea today.
All right, good. We talked about the evidence to start with, though, because you have the right to know the evidence against you in a case. Did you discuss that evidence with your attorney?
Yes,
All right, and do you believe that your attorney has provided you with effective assistance during the course of this case?
yes, very.
I'm not surprised. You've been lucky. According to your plea bargain agreement, let's see, we've also got an enhancement paragraph here. And we are going to have him plead to the enhancement paragraphs?
Yes, Judge.
It's a cap of 10, but
Yeah.
I think that it was, the paperwork reflected it was still
A second degree.
second degree. They just capped it at 10.
Very good. According to your plea bargain agreement, in exchange for your plea of guilty to evading arrest with previous conviction and a plea to the enhancement paragraphs, you are going to plead open to the court and a cap of 10 years in the Texas Department of Criminal Justice. Is that your understanding of the agreement?
Yes,
And would you like to enter into that agreement now?
yes,
To the charge of evading arrest with previous conviction, how do you plead?
guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes,
Based on your plea of guilty, based on stipulation of evidence, I find that there is sufficient evidence to substantiate your guilt. But I don't find you guilty at this time. There are two enhancement paragraphs. To the first, that you were convicted of assault, family violence, impeding breath, and cause number 15-0662-CR-C in the 25th Judicial District Court of Guadalupe County, Texas. How do you plead, true or not true?
True.
And on August 14th, 2019, you were convicted of evading arrest in a vehicle in cause number CR 17-1279C in the 22nd Judicial District Court of Hays County, Texas. To that enhancement paragraph, how do you plead, true or not true?
True.
I find that both of those are true. Right. And what I'm going to do now is order a PSI. That means that someone from probation is going to come and speak to you. After they have spoken to you, then the case will come back and do your sentencing at a future date.
Okay.
All right. That will be a different judge that was here at that time. And that judge will make the decision on what to do on your cap of 10. I haven't made a ruling as to deferred, although with enhancement paragraphs, you can get it deferred.
I don't know, Judge, I'll
He
confirm.
still can. It's not a minimum
Okay.
mandatory, but.
Okay.
It's not disqualifying for the court judge.
Okay. All right. So those decisions will be made by the next judge that comes in here. Anything else we need to take up? All right. Well, good luck to you, sir. I'm glad to see we've been here about the same amount of time.
Really?
And I've seen you come a long way from where you were. So I'm proud of you.
Proud of you.
All right. Well, thank you. Well, good luck.
Thank you.
Take care.
You take care.
Yep.
Your Honor, question for you.
Yes.
On Mario Stafford, are we resetting him for a punishment hearing? I know it's kind of confusing.
It'll be a status hearing.
Status hearing?
Yes, where you will present the judge with any other conditions that y'all want to recommend.
Thank you.
Okay, thank you.
May I approach your-
Yes, how are you doing?
Judge, very well. Good morning. Good to see
Good
you.
morning. How are you?
I'm here on John Mamalejo. I apologize to the court. We should have already filed a notice of appearance or a motion to substitute, which we hadn't done. He's set today. It's on the trial docket.
Yes.
I did not realize it was on the trial docket, but I'm trying to get it resolved today. If it doesn't get resolved, I'll reapproach the court, but at the very least, I'd ask if I'd be substituted in as attorney of record.
Okay, so we'll do that so that you can be taken care of as the attorney.
I came to announce we're not ready.
Okay, well, he sounds like he's gonna announce ready. I know he is, because this guy's always ready.
Anytime I've ever been in a courtroom with you, I've had to be ready.
That's right. Okay, well, y'all keep conferring.
We will.
Let me know where you are before we decide what we're gonna do.
I appreciate you.
Okay.
Thank you, Your Honor.
All right.
If we could reset Quincy Walker, he's on a pretrial motions.
Can I get Quincy Walker, please? Quincy, is Mr. Walker here?
He's not in jail.
Oh, wait, we need to get him up then. Okay? We'll bring him right up. His day in court, I gotta tell him.
Yeah.
Okay, let's put that in the Marmalade file. That set of papers that you gave me, Becky. What was it? You know, that when I came over.
It is an agreed motion to modify the scheduling order. 23-14-16. And I was came up with the motion and
And the what's that? So that's what I'm not finding, and that's where my docket was as well.
did you leave it?
Okay, 1 second, Alex. I'll be right back. Let me go look. And that what you're giving me. Yes, sir.
We're here for Leon Roman McKibben.
Okay, you ready?
We are.
Roman, come on up. Ruby?
What's the last name?
McKibben.
Oh, that's not it.
I'm sorry?
Not just.
Court calls CR 24-0004F, the state of Texas versus Roman Michael McKibben. Can council please make their announcements for the record?
Allison Booth for the state.
Alex Joyner for the defense.
And are you the same Roman Michael McKibben who in CR 24-004-F is charged with possession of a controlled substance, cocaine less than 1 gram?
Yes, sir, Your Honor.
Can you raise your right hand? Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right, this is a state jail felony as charged. State, what is the range of punishment?
Not less than 180 days, no more than 2 years in state jail facility, and a fine not to exceed $10,000.
Do you understand that is the range of punishment that you face for this charge?
Yes, sir, Your
I have paperwork.
Judge. Y'all slow down.
Sure. I have paperwork before me that indicates that you would like to enter into a plea bargain agreement. I'm showing you the court's admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir, Your Honor.
On page 4 of this document, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there's a stipulation of evidence. I will use that to determine if there's sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Indeed.
So this is an agreement between you and the state. I don't have to follow this agreement. But if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those rights, you still wish to proceed with this plea agreement.
I do indeed.
Are you a citizen of the United States?
Yes, sir, I am.
If not, a plea in a case like this could have serious consequences. Counsel, I have the discovery compliance statement before me regarding the state's duty to give you evidence in accordance with the Code of Criminal Procedure. Are you satisfied the state fulfilled that obligation?
We are satisfied, Your Honor.
And do you believe that Mr. McKibben is competent to enter into this plea?
Yes, Your Honor.
The reason that we discuss the evidence is because you have the right to know the evidence against you in a case. Did you discuss it with your attorney?
We did, sir.
And is there, has your attorney provided you with effective assistance during the course of this case?
He did indeed, sir.
According to your plea bargain agreement, in exchange for your plea of guilty to possession of a controlled substance, cocaine, less than 1 gram, the state will recommend 2 years deferred adjudication, a fine, restitution, fee, you'll do an evaluation, and you'll do community service. Is that your understanding of the agreement?
Yes, sir. it is.
Would you like to enter into that agreement now?
Yes, sir.
To the charge of possession of a controlled substance, cocaine, less than 1 gram, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir, Your Honor.
Based on your plea of guilty, based on stipulation of evidence, I find that there is sufficient evidence to substantiate your guilt, but I don't find you guilty at this time. What I'm going to do is order a PSI. Someone from probation will talk to you. After they have prepared a report for me, we'll come back here and do your sentencing at a future date. Understood?
Yes, sir.
All right. Good luck to you, sir.
Thank you, sir.
Thank you,
Thank
Judge.
you.
Yeah, thank you for your.
Yeah, pleasure. Appreciate it.
May we be excused?
Yes, you may. Make sure he talks first to the probation.
Absolutely.
Hello, Mr. Evans.
Oh, Your Honor, I'm ready to advance Jose Duran to the plea. I'm sorry, to the jury.
Mr. Duran, where are you?
He's in custody, Your Honor.
He is? Is he up here?
There.
Okay, can we please bring him up? With a custody plea paperwork? Give you that one back. How are you, Mr. Gray?
Good, Judge, how you doing?
Are you here on Jace Zeman?
No, Judge, I'm here for Robin Medina.
What about her?
If I can approach on her. Judge.
Okay. Is she here?
She's not, Judge.
Where is she?
Well, I just got in contact with her, Judge. She's saying that she's at the hospital with her brother. He's on life support. They're trying to make decisions. I'm trying to get medical documents from her as soon as possible to give to the court. I would just ask that the court give us a 5 before putting out a warrant to see if I can get those documents in.
Okay, granted.
Okay, thank you, Judge.
Yes, sir. And then take care of that other one too.
Yes, sir.
Let's go on Jace Zeman.
I don't know who that was on. Who is that on, Judge?
Medina.
Mendieta.
Oh, Mendieta?
Yes, page 3 of ours.
I thought that was on Medina. Judge.
Medina?
That's what I heard.
Oh. Mr. Green, are you here on Medina or on Mendieta?
Medina, Judge. Yeah, Robin's the first name.
On the jury, yes.
And Judge, that's the one where we've had multiple problems with her showing up and being on time and.
This isn't the first time with her?
No, Judge, she tested clean last time to give her EUA. I do think that her brother is in the hospital and just showing up.
Okay, and I trust you, so that helps, but we have a hearing this afternoon, so she needs, I said 5, but we need to be by 3.
Would you like her to come in person or just?
Yes.
Yes, sir. I'll
She
let her
needs
know.
to be here.
And announcement wise on that, state's ready.
He needs to be here too at 3. But I hear you. Oh, let me ask him now. So Diana Mendieta. Deputy, can you call that one 3 times? Mendieta.
Judge? Mendieta.
On page 3.
Mr. Green, on Medina, the state has announced ready.
That's our intention is to plead, Judge. We'll be ready if we can get in contact with with my client and get those papers in.
Very good. All right, let's stay on that today.
Yes, sir.
All right, you are Mr. Zeman?
Yes, sir.
Ruby?
What's the name?
Zeman, last one.
You finishing today?
Yes, Judge.
Yes.
Ready, start.
Court, no problem. Court calls CR 235476F, State of Texas versus Jace Arthur Zeman. Can counsel please make their announcements for the record?
Philip Giebert for the state.
Todd Nickel for Mr. Zeman.
And are you the same Jace Arthur Zeman who in CR 235476F is charged with theft, 30,000 to 150,000?
Yes, sir.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yeah.
This charge is a 3rd-degree felony. State, what is the range of punishment?
No less than 2 years, no more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000.
Do you understand that that is the raised punishment that you face for this charge?
Yes, sir.
I have paperwork before me that indicates that you would like to enter into a plea agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes.
And is this your signature on the final page?
Yes.
So this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you withdraw your plea and you can proceed as if this didn't happen. Understood? You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial, and you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes, sir.
Understanding those, do you still wish to proceed with this plea agreement?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this can have serious consequences. Counsel, I have before me the discovery compliance statement regarding the state's duty to give you evidence in accordance with the Code of Criminal Procedure. Are you satisfied that the state fulfilled that obligation?
I am, Judge.
And do you believe that Mr. Zeman is competent to enter into this plea?
I do, Your Honor.
The reason we talk about the evidence is because you have the right to know what that evidence is against you. Did you discuss it with your attorney?
Yes, sir.
And do you believe your attorney has provided you with effective assistance during the course of this case?
Yes, sir.
According to your plea bargain agreement, in exchange for your plea guilty to theft, 30,000 to 150,000, the state will recommend 2 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served. Is that your understanding of the agreement?
Yes, sir.
Would you like to enter into that agreement now?
Yes, sir.
To the charge of theft, 30,000 to 150,000, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
State, have you given notice to the victim of the proposed resolution today?
We have, Your Honor.
Were the excavator and steer recovered?
Yes.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Is there any legal reason we can't proceed to sentencing?
No, there are two quick things I just wanted to clarify for record purposes only. I can do that really quickly. One of them is he's currently on probation in Bastrop. And so this plea can obviously affect that, but we already have a plea agreement worked out there as well. And so I just wanted to clarify that for record purposes. And the other one is there's been a ongoing hassle of trying to get credit for some jail time he had in custody in another county, but rather than fight that fight, the states changed their offer and reduced it to compensate for that. So it's sort of all baked in. I've explained that to my client. He understands that. But if there's a jail credit question that comes up later.
Is that your understanding of the agreement?
Yes, sir.
And knowing all of that, are you comfortable proceeding with this plea agreement?
Yes, sir.
That's all I
All
had. Thank you.
Yes, sir. Any argument from the state?
Just to follow the plea agreement.
Any defense?
No, Your Honor.
Having found you guilty of theft, 30,000 to 150,000, the court sentences you to 2 years in the Texas Department of Criminal Justice. You will get credit for the time that you have served. Is there anything else that we need to take up?
No, Your Honor.
No, Your Honor.
Sir, I have followed your plea bargain agreement, and because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification that will be added to your file. Good luck to you, sir.
Thank you, Judge.
Right, something. Nothing done. Yeah, it was. Perfect.
Yep. Thank you. Thanks for coming in.
I love to see that.
Okay.
Students, I love that the students and all that. It's just.
We've done that for 2 years. We've been working with them.
It's a good reminder for old
Yeah.
lawyers too. But
Yeah, no, it is.
see
Well,
some wide-eyed
it's-
people
it's-
learning about how it really works.
It says in the code of, in our code for judges is that we are supposed to be educated.
Yeah.
I tried.
Appreciate it.
Thank you.
Thank you.
Thanks for saying hello. Is your client here, Mr. Evans?
Yes, Your Honor.
And tell me your name, please.
Jose Durone.
Mr. Jerome, can you approach, please? Morning, Mr. Jerome.
Good morning, Vic.
Your attorney has been in here conferring with counsel for the state, and he's approached me. We're just gonna come in to let you know what the status of your case is. Defense?
We're asking this to be settled during trial.
All right, this was a plea setting, and as I told you last time, if there was no resolution, we would move it to the trial setting. We're going to do that now, so the next time you come in, it will be a trial setting. Understood? You have any questions?
On what day?
I don't know that yet, but she'll be able to tell you in just a minute. Is there anything else we need to take up?
No, Your Honor.
Nothing for the state.
All right, thank you. Mr. Evans, have a good day. So emblematic of things. And your client's coming up? That's
Later on.
Mr. Walker? Why is he in jail? Why is he in jail?
Made a tour of the jail. And we can send it back. That's the FDA,
Okay,
colorful character.
so we're gonna take care of his case today?
I'd rather reset it so I can.
Okay. Well, we're moving it to a police, we're gonna move it to a police setting. Wanna run through the docket real quick, Becky? First page is done. Christopher Gia,
He's waiting for his attorney.
and what happened there?
He's got
He was
his-
approved an attorney. He wasn't paid how many first and care absence.
Okay. So stick around, Mr. Gia, your attorney's on his way. Jeffrey Lopez. What happened on his? Do you get appointed attorney?
Did you
I can't, come up, please, I just can't hear you.
My attorney had to go get another client of his out of jail, so he wasn't able to show up today.
Okay, who's your attorney?
Daniel Gordon.
Daniel Gordon?
Yes.
Where is he based?
I think he's based in Austin. I don't remember his exact address, but it's in Austin.
Has he made a notice of appearance?
No, it's not, because he's still in the process of being retained. He emailed me yesterday.
Okay,
So he's just not filed anything.
all right. So when was the last time you were in touch with him?
Last week.
Okay. And what was the situation that you had with him?
He notified me that he wasn't gonna be able to make it. He said he was gonna try to get it reset. But I think it was like around 10, he said he wasn't able to get the reset.
State anything I need to know here?
Judge, I don't have any notes regarding Mr. Lopez.
All right. While we are waiting to find out more, can we give him a call?
I can read you the email he sent me.
Okay,
He did ask for a reset. I told him no.
okay,
Told him his client needed to appear because he technically was not the attorney of record. Without a letter of rep or a waiver of arraignment,
Right.
the case cannot be reset. Told him his client needed to appear to fill out an order to employ counsel.
so are you going to, if he doesn't show up for you, do you want counsel appointed or do you plan on hiring someone?
Well, I've already paid him.
You paid him?
Yes. I paid him. I think it
Well,
was.
then why would he say that he's not your attorney yet?
Well, I think the payment is still being processed. We already paid him 1,500 yesterday.
Okay. All right, well, let's wait around and look into it. In the meantime, I want you to go downstairs and with Rosa and take a drug test. Are you gonna be clean?
Probably not.
Okay, what are you gonna be dirty for?
Probably marijuana.
Poly marijuana? What else?
That's it.
Okay, when was the last time you used?
Probably a few days ago.
Okay. Okay, we'll just see her and make sure you come back up after you're done. Okay? Rosa, can you please handle this? Stick, I want to look to you for guidance. Johnny Martinez. Is your client up?
Yes, Your Honor, and he would like to take the plea offer, so.
Oh, okay. All right, well, let's do it.
Get that done.
Get to work on that. Jesus Marine. Sign the waiver on Jesus Marine. Dwayne Reichel. Call that name 3 times, please. Can someone tell me what his bond is?
Believe you last raised it and it's currently at an open warrant based on that.
It's already been raised.
You raised it after being notified by pretrial supervision of a positive UA and he has since not joined us
Dwayne
today.
Reichel, REI. Probation in touch with me or pretrial services on the violation?
I don't know. I just glanced at it.
Who did? Pretrial?
The Green was trying to locate his client.
Yeah, well, thank you, Johnny Ray Martinez.
Each Darwin is in another county first.
Okay. What happened with Bill Campbell? Is he gonna come back on Julio Martinez? Don't know. Diana Mendieta,
That's her name be called 3 times.
3 times. Can someone tell me what her bond is?
1,000 on both ends.
Okay. Make it 5,000 on both counts. Cash surety. Rosa,
Yes, sir.
can you tell me about your office's latest contact with Dwayne Reichel? Or any efforts that you've made to reach him? REI. So that's it on 3. On 4. Complete Mr. Indera, that's going to be everything on 4, correct?
Yes.
Okay, great. So on the trial criminal docket, Marmolejo is still conferring, is that right, State? On,
Molly, Marmolejo.
okay, great.
What did you say?
We'll have a plea.
Robin Medina is the one that he doesn't know where she is that right?
Supposedly at the hospital.
Hospital. She has till 3. State's announcing ready. And we're still waiting on the Mendoza. Very good. And then on,
Just back to Jeffrey Lopez. And back from Attorney Daniel Gordon, who will be filing the letter today.
okay, is he gonna do a
Waiver.
waiver today?
First, you know that I needed a waiver of agreement as well.
Okay. Well, we'll see what happens here in a few minutes when,
But he's not coming
okay,
today.
we'll see what happens in a few minutes. I have. Will you pass this to probation, please? Probation, have you heard from Dwayne Reichel lately? Okay. Yeah, of course you can.
These are the conditions for Marius. I just need your signature.
Oh,
This
fantastic.
one, they're finally done.
We're back to, well,
And here's his sex offender ones as well.
I'm excited that we have the old paper is back. I heard the machine was broken and there was no parts to,
These are the back.
what's that?
These are the
Ruby, we have,
backups.
do you know what this is, Jack? Have you ever seen this? How old are you?
17.
Yeah, this has been out of use for more time than you,
I've
yeah,
been alive either.
yeah. So this is
Sorry.
what they used to print on, and it would come out in this one long thing, and then you tear it
Yes,
at each part. And we still use it here.
It works.
It makes it easier for court stuff because then everybody gets a copy.
I like it. I think it's,
And then
it's-
regular paper for his sex offender ones.
we're not,
Is that printer with like considered the dot matrix?
I don't-
Printer?
oh, yeah.
Yeah, I was like, I
Yeah,
don't know.
it is. Yeah, it's a dot matrix.
I love it. Thank you.
No, I thought you were only using it until you run out of the paper,
Well, I think somebody sabotaged the printer, honestly. And it broke.
but it's back working because you have it today.
These are backup copies that we have stored away. For
Oh.
my private stash.
For moments like these. Okay,
And then we're gonna get him to sign these when he goes down to probation for a transfer, Your Honor.
great. Thank you. On Dwayne Reichel, can you tell me what status is?
The last time that he reported to Emily was November
He reported when?
well. That's the last time that
Oh.
November. November
No
the 12th.
contact since.
No, sir. I can tell that she's been sending him text message reminders that he needed to be here. So he knew that he needed to be here. He got one on the 8th and one on the 9th.
Okay, thank you. Are you ready on Mr. Walker?
We are, Your Honor.
Good morning, yeah.
Good morning, how you doing? All right, we're gonna sentence today too?
Yes, sir.
Court calls CR 234899F, the state of Texas versus Quincy Kinsey Walker. Council, please make their announcements for the record.
Philip Giebert for the state.
John Hindera for Mr. Walker.
And are you the same Quincy Kinsey Walker who in CR 234899F is charged with theft to prior theft convictions? All
Yes, court.
right, can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
So help me God.
All right. Today, this is a state jail felony. State, what is the range of punishment for a state jail felony?
Not less than 180 days, not more than 2 years in a state jail facility.
Do you understand that as the range of punishment that you face for this charge?
I do.
I have paperwork before me that indicates you would like to enter into a plea bargain agreement. I'm showing you what is the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this paperwork with your attorney and discussed its contents?
Yes, sir.
On page 4, there are a list of rights that you would be waiving if you enter into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, sir.
And is this your signature on the final page?
Yes.
Sir, this is an agreement between you and the state. I don't have to follow this agreement. But if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Correct.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Correct.
Understanding those rights, do you still wish to proceed with this plea agreement?
For the year state jail. Yes.
We're going to get to that.
Yes, sir.
All right. But you understand all your rights
Yes, sir.
and understanding that you want to move forward.
Correct.
All right. Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have the discovery compliance statement regarding the state's duty to give you evidence in accordance with Article 3914 of the Texas Code of Criminal Procedure. Are you satisfied that the state fulfilled that obligation?
I am, Your Honor.
And do you believe that Mr. Walker is competent to enter into this plea today?
He is.
The reason we talk about the evidence against you is because you have the right to know what that evidence is. Did you discuss it with your attorney?
Of course I did.
And did you,
He's the best.
what's that?
He's the best.
Yeah, good. And did, did he provide you with effective assistance during the course of this case?
Immensely.
Immensely. All right. According to your plea bargain agreement, in exchange for your plea of guilty, the state will recommend 1 year in the state jail facility and you will get credit for the time that you have served. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
For the 174 days of back time, right? Yes.
You
Yes. Yeah, I'm just making sure. Yes, sir.
All right. To the charge of theft, 2 prior theft convictions, how do you plead?
I plead guilty.
Are you pleading guilty because you are guilty and for no other reason?
I'm pleading guilty because I am guilty of crime.
All right. State, have you given notice to the victims of this case of the proposed resolution?
Judge, the victim is a corporate entity and we will reach out by email and let them know.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate this guilt. It substantiates your guilt, and I find that you are guilty. Is there any legal reason we can't proceed to sentencing at this time?
None from the defense, Your Honor.
None from the state,
Any argument?
just to follow the plea agreement.
Argument?
We just want to follow the agreement.
Based on finding you guilty of theft, 2 prior theft convictions, the court sentences you to 1 year in the state jail facility. You will get credit for the time that you have served. Is there anything else we need to take up in this case?
No, Your Honor.
Sir, I followed your plea bargain agreement. Because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. That will be added to your file. Good luck to you, sir.
Thank you, and and also I want to wish you good luck on your future endeavors.
Oh, thank you very much.
You're welcome.
Thank you, Your Honor.
Even the defendants are being kind to me.
Thank you, Your Honor.
Yeah,
Your
Mr.
attorney
Nair,
should be able to
pleasure.
Get you one once they.
Thank you for what you do.
So-
Happy holidays, Your Honor. Thank you. Good luck. Doing a great job. Giving Ashley a run for her money. I do have a soft spot for Ashley. She's been here for a long time. Came around. Okay. Who are we waiting on then?
Normal labor judge. This paperwork out.
Okay. And Lopez is gonna come up with results. Case Darwin. You need to be here at 1:30. Deputy, so on Martinez, just keep him.
Okay. We also have.
And Julio Cesar Martinez, I thought Campbell was coming back on that. He said there was. Well, can we find out where he is? Because I need to talk to Martinez.
Yeah, I thought he was.
Huh?
I thought Campbell was coming back to that.
Yes, he told us he was coming back and I haven't spoken to him yet. I need to let him know what the status is. So if he can't come back, then we'll see him at 1:30. Mr. Campbell and Mr. whoever Campbell's client is. Christopher Gia is waiting on Mendoza. Okay, we'll see if we get here before then. Is there anyone else?
The jury on it, Kayla Rain.
Yeah. So we'll keep her too. Did you hear from Linda on the Reisenberger versus HEB case about the attorneys?
Okay, bye.
I guess it stays still, yeah, I guess it stays still pending.
And I said, okay, so they're not coming today, and she said that plaintiff is not coming, she's announcing not ready. They were confused because the last setting they were allowed to announce via email, they didn't know that they had.
Okay.
What place is that, Becky?
Alana, the HEV. Mary, please.
Just the amended conditions on Solis from.
What's that?
The amended conditions for Solis.
Okay. And are we ready on Marmolejo? Is there any, what are we waiting?
I'm just popping signature on it.
Okay.
The judge on the civil period, I think you just have to leave left or do you have?
The second one, 21-26-56, the child case is still pending.
Yes.
COP is coming back.
Yes.
MCRT is the document that you gave me. And I haven't reviewed it yet.
Okay.
Have you already gone over the paperwork with your client?
I have judge, I just need to be sworn in and then we're ready to go.
All right.
Yeah, Coach.
Are you gonna be the last attorney that comes before me in a criminal case?
I don't know.
If it is, I like that.
I do too, yeah. I was telling your prosecutors that you and I used to mix it up in the courtroom when we were younger and more vicious.
Did you tell them how calm I am these days?
I didn't get into too much
Right, good.
detail.
Okay, got it.
Yes, ma'am.
What's his client's name?
Marmolejo on the trial docket. Okay. Check, we'll talk in after this one. Okay. You doing okay? A little bit of everything that goes on today, isn't it? There he is. We need to get your client up?
Yes, sir.
Can we get his client up, please? Ready? Dick? Ruby?
Ready, Judge.
Court calls CR 24-1557F, the state of Texas versus John Anthony Marmolejo Jr. Can counsel please make their announcements for the record?
Molly Smith for the state.
Neil Kalfas on behalf of Mr. Marmolejo, Your Honor.
And are you the same John Anthony Marmolejo Jr., who in CR 24-1557F is charged with harassment of a public servant?
Yes, sir.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, we're here today because you can put your arm down. Because you're charged with a third-degree felony. State, what is the range of punishment for that charge?
Not less than 2 and not more than 10 years in TDC and a fine of up to $10,000.
Do you understand that is the range of punishment that you face for this charge?
Yes, sir.
I have before me paperwork that indicates you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir.
On page 4, there are a list of rights that you would be waiving if you entered into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose? Did you know I would use that for?
Yes, sir.
Very good. And is this your signature on the final page?
Yes, sir.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow the agreement, I'll allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir.
You don't have to plead at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial, and you have the right to have your attorney cross-examine any witnesses that the state brings against you. Do you understand those rights?
Yes.
Understanding those rights, you still wish to proceed with this plea agreement. Are you a citizen of the United States?
Yes, sir.
If not, a plea in a case like this could have serious consequences. Counsel, I have the discovery compliance statement regarding the state's duty to give you evidence in accordance with the Texas Code of Criminal Procedure. Are you satisfied the state fulfilled that obligation?
Yes, sir, Your Honor.
And do you believe that your client is competent to enter into this plea today?
I do so believe, Judge.
And the reason that we talk about the evidence is because you have the right to know what the evidence is against you. Did you discuss that evidence with your attorney?
Yes, sir.
And are you satisfied your attorney has provided you with effective assistance?
Yes, sir.
According to your plea bargain agreement, in exchange for your plea of guilty, the state will recommend deferred adjudication for 2 years. There will be a fine, a fee, an evaluation, community service, an apology letter, and there's a particular caseload that you will be on. Is that your understanding of the agreement?
Yes, sir.
And would you like to enter into that agreement now?
Yes, sir.
To the charge of harassment of a public servant, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
State, have you given notice to the victim in this case of the proposed resolution?
We will today, Judge.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, but I don't find you guilty at this time. What I'm going to do is order a PSI. That means that someone from probation will talk to you after they have prepared a report. You'll come back at a future date and a different judge will be here to sentence you in accordance with your agreement and the terms and conditions recommended. So make sure that you cooperate with the probation. Understood?
Yes, sir.
All right. Thank you very much, sir. Anything else we need?
That's it.
No, Your
Thank
Honor.
you. All right, we're off the record.
See you.
Good to see you again.
Yeah, you too. I'll talk to you soon.
Look forward to it. Is he up? This is on, tell me his name, please.
Julio Martinez.
Julio Martinez.
So 2 things, he wants a reset to possibly bond out. And then he wants to talk to the court about a new attorney.
How you doing, sir?
How you going, sir?
You okay today?
Yes, sir.
All right. You tired?
No, sir.
All right. All right, we're here today for a plea setting. And as I told you last time, that if we were not able to reach a resolution, the next setting would be for you to go to a trial setting. Is there a resolution in this case today?
No, sir.
Okay.
Is there any way I can get another attorney? I feel unconfident that he's trying not to try to help me. He hasn't tried to help me in any way. Is there any way I can get another attorney?
So the way it works is that the judges here in the district courts in Hays County have decided that we believe that this attorney does a good job for his clients, and we make the appointments of him to these cases. So we believe in him. Are you cooperating with him when he speaks to you?
Yes, sir.
You're talking to him?
Yes, sir.
Okay, well, you have the right of an attorney, and that's why we have appointed one, but you don't have the right to choose that attorney.
What if
I, like
wanna-
my colleagues, believe in this attorney, and so he will remain your attorney.
What if I want to hire my own
Well,
attorney?
you're welcome to hire your own attorney, but you need to let that person know that if you're going to trial in 30 days, and so that person's not going to be able to come in here and say, well, I just got this case, so give me another delay. You changing attorneys at this point will not be the grounds for a delay. Understood?
I know,
Okay, well,
I'm just,
if you want to get another attorney at any point, you're allowed to do that. But you have an appointed attorney now. I have confidence in him. He will remain your attorney based on everything that I know. And you will be set for trial at your next setting, which will be in approximately 30 days. All right, at that point, then if you have a new attorney, you need to make sure that you or whoever's going to hire the attorney for you, if it's someone from your family, you need to make sure that they tell that attorney from the beginning that you are hiring him for trial. Because the next setting is a trial, and what I'm trying to let you know is you can't use that as a reason to get another continuance.
okay, if I keep this attorney, I'm still able to get bonded out.
You could get bonded out under those right circumstances.
Because I'm trying to get the money to bond out.
Okay, well, good
So if I
deal.
keep him, I'm able to bond out still?
You're able to bond out at any point that you can do what is necessary to get the bond. Right?
Okay.
And he's your attorney until such time as you come in and tell me that you've hired someone new. At this point, you have a good attorney who will represent you. And he's been in here this morning and he's been arguing on your behalf. He's been conferring with the state. That's why we bring you up to let you know what the status of your case is.
What about a 1244? Am I eligible for a 1244?
So I'm not going to make the decision about whether that happens. That's the negotiations that happen between your attorney and the state. And if you've asked your attorney for it and you can pitch it to the state, they can let you know. But I'm not going to get involved in your
Okay.
negotiations.
Okay,
But no, statutorily, that's not an offense that would be eligible for consideration under 1244.
So there's your answer from the
Okay.
state. Has to be a state jail felony. You have a 3rd-degree felony.
so if I keep him, I'm still eligible to bond out.
You are eligible no matter who is your attorney to bond out. Do you have a bond? Can someone tell me what his bond is?
Can I get a bond reduction? Please?
Your bond was increased, as I remember it, right?
Yes, and then they re-magistrate.
Oh, that's right. You came in and tested positive for meth, THC, and amphetamines. Is that right?
Yes, ma'am.
I remember
Yes,
you didn't look so good that day.
sir. Yes, sir. Now I'm bad,
Now
But you
you're
helped-
clean,
But
but
you helped me out and everything. It's just, if I can get a bond reduction, so
that wasn't very long ago. And I have no reason to believe right now that something has changed in your mind. What has changed in your mind that that's not going to happen again? Other than you spent time in jail.
that I wanted to second, I want a second chance. And I realized it in life.
Okay. Are you doing NA classes at the jail?
I'm trying to get in any kind of classes.
Okay, but you're not
that's
doing
why
NA? I recommend that you get started with NAs at the jail. I know that they have it. It's a good way for you to be moving forward. Okay,
So my bond will still be set at 10,
that's your bond is set. That's what your bond is set at.
so I'll be able to bond out on 1,000.
I don't know what a bonding agency is, what kind of agreement they're gonna come to with you. All right, but from what I'm hearing is that you do not have an agreement today. You understand that a 1244 is not available and there is no other agreement. So you will go until such time as you bond out or until we have a trial and your case is resolved. You're gonna go back with the deputy today. Understood? Okay, and just because it's a plea setting, I want to be sure from you, you don't have an agreement on anything? You don't have a plea agreement?
Man,
So if I may, Judge, so I've explained to you today a couple of times, right? The state is offering you 4 years in prison. you don't want to take that, I understand that. The state is also agreeing that if you plead open to the court, in other words, plead guilty, the state's okay with that. And then you would be reset for approximately 6 weeks, whether you're in jail or out of jail. For probation does a pre-sentence report. They look at your employment history, criminal history, social history, any mental health issues, substance abuse issues. And we come back for sentencing, and judge can do whatever he wants with you. And so you chose that route. You're agreeing to that up front. He could give you probation. He could give you 2 to 10 years in prison. He could give you standard probation. He could give you deferred adjudication probation, which means that if you successfully completed that, you have no felony conviction. So those are the options for the court.
Why don't you two step back
Okay.
and discuss that further?
Yes, sir.
But thank you for listening and cooperating with your attorney.
Yes, sir.
What are we doing on case?
Yes. Okay, we're just trying to see if we're gonna get this worked out.
Okay, do you have the paperwork done yet?
No. we're working on it.
Okay, then we'll do it at 1:30.
Yes.
All right. Anything else that we have right now? Okay, so Mr. Gia, please come back at 1:30. Who else needs to come back at 1:30? Oh, he has this pen. Yeah. Okay, all right. And Lopez is, who's that one?
Send him downstairs to do.
Have you heard what's happening with him?
No, sir, I think they left.
They left?
Jason is on his way up.
I'm sorry?
Jason is on his way up.
Okay, all right. Tell him he needs to be back here at 1:30.
Yes.
Did you know the results of his test?
No, sir.
Okay. All right. Green, we have you on Medina.
Yes, Judge. That's one day. We just probably hopefully can turn in medical paperwork by 3 p.m. today.
Okay.
It's Medina. The other one was Reichel, Dwayne Reichel. Our offices reached out. We're not able to get a hold of him. So we'll update the court if we can, but we have no contact as of right now.
Okay, so we need you to come back. Well, I don't know if you want to wait at your office, but Medina needs to be here by 3. And if y'all are going to take the pleas, then you would do it by that time. I'll be in another hearing, so we're available for you.
Okay, sounds good, Jim. I'm
Okay.
here for Misdemeanor Court this afternoon anyway, so I'll remember you. Yes,
Okay, all right, sounds good. Anyone else?
I think that's it for me.
Are we gonna do pieces right now?
No, we're doing it at 1:30.
Okay, I just saw him.
Yes, we're doing it at 1:30.
Okay.
You filling it out right now? Are you filling it out right now, Case? Are you doing it right now?
Yeah, I'm getting you signed up right now.
Okay, I mean, do you want it? We can do it.
If we have time, yeah, that'd be great.
All right, I don't want to hold you. All right, let me do that.
But if you give me a minute or two, we'll have it ready.
Okay, I'll give you a minute.
Okay.
Jason,
Tell me to come back at 1:30.
what's that? No, let's see what was the result?
Positive for marijuana.
Positive for marijuana.
Yes, sir.
Well, you said you'd be positive for marijuana. So he has a Lopez. Lopez, do you have a job? Do you have a job? What do you do?
I work for In Charge. It's an electrical company.
Okay. Are you working tomorrow?
Yes.
Are you working on?
We work Monday. We work Monday to Friday, from 6 to 3.
Okay. What Becky then is the status? Will you remind me? I'm sorry. I know you have.
He has been paid. The attorney's name is Daniel Gordon. I let him know that he filed his letter of revenue waiver of the lien.
Okay, so here's what the situation is. We have to get this paperwork so that the process can get started. He is going to put in that paperwork. I'm going to set your case for tomorrow at 9 a.m. However, If a waiver is received before the end of the day, then you don't have to be here. Okay, so talk to the coordinator there, and she's gonna tell you what that means. All right? Means you don't have to come tomorrow if
that waiver comes in.
that's right. And look, I'm not saying you have to do the waiver, but if you don't do the waiver, we'll come back tomorrow and I'll do your arraignment. But we just need to move your case forward. And you're here and you're doing what you were asked to do. By the way, don't do any more marijuana.
Yes, sir.
Okay, that's part of the agreement to be on bond.
Okay.
All right. So, or maybe Donkey, you can explain that. Well, Becky, can you explain that situation to Mr. Lopez? Of the, yes, with regards to the reset, but if we get the waiver, then he doesn't have to be here. That is slide right over. Slide right over. State.
Morning, Judge.
How you doing?
I'm actually doing all right, man. I got a lot of high hopes going on right now.
There you go. Good. And what brought on these high hopes?
Great man right here.
Yeah. You're lucky.
Great man in the parole board.
You're good. It's a good attorney.
The reviews online, he got like 4.5 stars.
Yeah.
Good, man. Real good.
But is it out of 10? Is it 4.5 out of 10 stars or 4.5 out of 5 stars?
4.5 out of 5 stars.
Okay, all right, that makes sense. Well, good. And like,
man.
huh?
Awesome, man. When I heard about that, I was like, oh man, we're in there.
You're in. We'll look at you. Now you got something taken care
He
of.
was probably paying bots for those stars.
You ready, Ruby? Court calls CR 24-0674F, the state of Texas versus Johnny Ray Santos Martinez. Can counsel please make their announcements for the record?
Philip Giebert for the state.
Case to order on behalf of Mr. Martinez, Your Honor.
And are you the same Johnny Ray Santos Martinez who in CR 24-0674F is charged with theft, $30,000 to $150,000?
Yes, sir.
Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the
I swear
truth.
to tell the truth, the whole truth, nothing but the truth.
This is a third-degree felony. State, what is the range of punishment?
Minimum 2 years, maximum 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that is the range of punishment that you face for this charge?
Yes, sir.
I have paperwork before me that indicates you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, sir, I have.
On page 4, there are a list of rights that you would be waiving if you enter into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, sir, I did.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient or insufficient evidence to substantiate your guilt. Did you know I would use it for that purpose?
Yes, sir, I did.
And is this your signature on the final page?
Yes, sir, it is.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, sir, I do.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial.
Yes,
and you have the right to have your attorney, 4.5 stars in all, confront any witnesses that the state brings against you. Do you understand those
Yes,
rights?
sir, I do.
Understanding those rights, do you wish to proceed with this plea agreement?
I wish to proceed.
Are you a citizen of the United States?
Yes, sir, I am.
If not, a plea in a case like this could have serious consequences.
Okay.
Counsel, I have the discovery compliance statement before me regarding the state's duty to give you evidence in accordance with the Code of Criminal Procedure. Are you satisfied the state has fulfilled that obligation?
I am, Your Honor.
And do you believe that Mr. Martinez is competent to enter into this plea?
I do, Judge.
The reason we talk about the evidence is because you have the right to know what the evidence is against you in your case. Did you discuss it with your attorney?
Yes, sir.
And are you satisfied that your attorney has provided you with effective assistance?
Yes, sir, I have.
According to your plea bargain agreement, in exchange for your plea of guilty to theft, $30,000 to $150,000, this state will recommend 3 years in the Texas Department of Criminal Justice. They will give you credit for the time that you have served. Is that your understanding of the agreement?
Yes, sir. I just have one question.
Okay.
Is this case running concurrent with Bear County?
I don't have that written on here, but did you guys intend for it to?
Yeah, Judge, the default is to run concurrent, so,
Okay,
yeah,
All right.
okay,
it says concurrently on the judgment.
okay, thank you.
Sometimes the judgment gives more information than this.
All right.
All right, so understanding that's the plea bargain agreement, do you wish to proceed?
Yes, sir.
To the charge of theft, 30,000 to 150,000, how do you plead?
Guilty.
Are you pleading guilty because you are guilty and for no other reason?
I am being guilty because I'm guilty.
State, have you given notice to the victim of the proposed resolution today?
Yes, Judge.
Based on your plea of guilty, based on the stipulation of evidence, I find there is sufficient evidence to substantiate your guilt, and I find that you are guilty. Is there any legal reason we can't proceed to sentencing?
No, Your
No, Your Honor.
Any argument from the state,
Just to follow the plea agreement.
from the defense?
we weigh it, Your Honor.
Sir, having found you guilty of theft, 30,000 to 150,000, the court now sentences you to 3 years in the Texas Department of Criminal Justice. There is no fine. You will get credit for the time that you have served.
Okay.
I must let you know that because this is a felony, you are ineligible to possess a firearm or ammunition. You understand?
Yes, sir.
In addition, I have followed your plea bargain agreement, and because I have followed your agreement, you do not have a right of appeal, and I'm signing the trial court certification. Is there anything else we need to take up in this case?
No, Your Honor.
No, Your Honor.
All right.
Thank you.
Very good luck to you, sir.
All right, thank you, Mayor.
You're gonna go up 1 degree in the future. You come to felony. And if you come first, you'll be 5 to 15 minutes. So it seems to be the end of the road.
Hold on, Case.
Yes, sir.
Were you appointed?
Yes, I will.
Yes, Mr. Campbell.
Ready for a plea on this one?
Okay, last plea. Then we're going to lunch.
Never.
I faked that a couple of times. Do you have any for you?
No, I'm getting.
Come on, come on up.
Yeah. I need a break, actually, regardless.
Okay.
Yes.
Case.
Yes, sir. Sorry.
And it's open, okay.
Nothing. I've enjoyed it.
Yes.
Thank you very
You
much.
too.
It's good. From San Antonio to here, we'll just keep moving around and finding each other.
Well, are you gonna be
Great.
around? Are you Austin or? Do you
I
know?
don't know,
We'll see.
Yeah.
Well, good.
but thank you for all you do, and you do a great job.
Thank you. I appreciate that. Hopefully you get some time off.
I don't want that. I want to keep working.
At least a month.
Merry Christmas.
Yeah.
Brian, it's fun. Yeah, that's fine. Ruby?
Okay.
Court calls CR 24-2360F, the state of Texas versus Julio Cesar Martinez. Can council please make their announcements for the record?
Allison Boost for the state.
Bill Campbell for the defense.
And are you the same Julio Cesar Martinez, who in CR 24-2360F is charged with unlawful possession of a firearm by a felon?
Yes, Your Honor.
You're that person?
I'm sorry. I
Yes,
didn't-
Your Honor.
Okay. Can you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right. We are here on your unlawful possession of a firearm by felon charge. That is a 3rd-degree felony. State, what is the range of punishment?
Not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000.
Do you understand that that is the range of punishment that you face for this charge?
Yes, Your Honor.
I have before me paperwork that indicates that you would like to enter into a plea bargain agreement. I'm showing you the court's written admonishments, the waiver of rights, and the stipulation of evidence. Have you been through this packet with your attorney and discussed its contents?
Yes, Your Honor.
On page 4, there are a list of rights that you would be waiving if you enter into this plea bargain agreement. Did you know that you'd be waiving those rights?
Yes, Your Honor.
On page 5, there is a stipulation of evidence. I will use that to determine if there is sufficient evidence to substantiate your guilt. Did you know that I would use it for that purpose?
Yes, Your Honor.
And is this your signature on the final page?
Yes, Your Honor.
Sir, this is an agreement between you and the state. I don't have to follow this agreement, but if I don't follow this agreement, I will allow you to withdraw your plea and you can proceed as if this didn't happen. Understood?
Yes, Your Honor.
You don't have to plea at all. You have a constitutional right to go to trial. You have the right to remain silent during that trial. And you have the right to have your attorney cross-examine any witnesses that are put up against you. Do you understand?
Yes, Your Honor.
Understanding those rights, do you wish to proceed with this plea agreement?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
If not, a plea in a case like this could have serious consequences. Counsel, I have the discovery compliance statement before me regarding the state's duty to give you evidence in accordance with the Code of Criminal Procedure. Are you satisfied the state fulfilled that obligation?
I am, Your Honor.
And do you believe that Mr. Martinez is competent to enter into this plea?
That is my opinion.
The reason we talk about the evidence is because you have the right to know the evidence against you in your case. Did you discuss that evidence with your attorney?
You know, I asked for a discovery pack, but I never have received one.
Okay. Have you discussed the evidence in your case that you know what the evidence is against you?
What they have said, yes, sir.
Okay. And you know what they're charging you with and what the evidence is to support that allegation. Is that right?
Yes, so by a witness.
Okay. And you understand then what the evidence is in this case?
Yes, Your Honor.
All right. Understanding what you know about the evidence, do you wish to proceed?
Yes, Your Honor.
According to the plea bargain agreement, in exchange for your plea of guilty, there will be no recommendation of an agreement. The court will have the full range of punishment before it. Is that your understanding of the agreement?
Yes, Your Honor.
Would you like to enter into that agreement now? Would you like to enter into that agreement?
Be out now.
Well, what I'm asking you is if you want to enter your plea, we're going to come back and do your sentencing at a future date.
Yes, sir.
Okay,
Yes, Your
so
Honor.
you want to enter that plea today?
Yes, Your Honor.
Is anyone making you do that?
Say yes or no.
No, sir.
This is your choice,
Yes, sir.
and this is what you want to do?
Yes, sir.
To the charge of unlawful possession of a firearm by a felon, how do you plead?
No contest.
No, you got to plead guilty.
Guilty.
Are you pleading guilty because you are guilty and for no other reason? Are you pleading guilty because you are guilty?
For carrying a firearm? Yes, sir.
Okay, are you pleading guilty to unlawful possession of a firearm by a felon because you are guilty of that crime?
If that's what the state's saying, yes, sir, Your Honor.
Okay, and do you want to enter into that agreement?
Yes, Your Honor.
Okay. And you've pleaded guilty, is that right? You've already pleaded guilty, and that's what you stand behind that?
Yes, that's what they're saying, yes, sir, Your Honor.
Okay, well, I'm not saying, I need to know that you are saying that you are guilty. You know what the allegations are. Are you pleading guilty to those allegations?
Yes, Your Honor.
Very good. What I find is that there is sufficient evidence to substantiate your guilt, but I am not going to make a finding at this time. That means that you will be subject to the full range of punishment, including you could get deferred adjudication from the judge who will hear this case. I'm going to order a PSI. That means that someone from probation will speak to you. If you are, when you're spoken to by the probation, make sure that you cooperate with them.
Yes, Your Honor.
All right. Anything else we need to take up?
Judge, I would request this time to let Mr. Martinez out on personal bond pending PSI.
State.
Judge State is not in agreement on that.
I mean, here's the thing that I would ask the state. You are agreeing that he could get deferred adjudication, right?
It's a possibility, yes, Judge.
Okay, and if he could get deferred adjudication, he would be let out. Why not let him out now if you agree to that possibility?
Judge, the state would ask that the PSI be completed in the event that inpatient treatment is recommended, then it's actually going to be beneficial for him to stay in custody. It will shorten any wait time for him having to go back into custody and be clean for a certain period of time before he can complete that inpatient treatment. Just because he's eligible for deferred adjudication does not mean that the court is going to grant it. Based on his history, as well as his substance abuse during the pendency of this case, the state's recommendation is that he remain in custody pending that PSI and sentencing by the court.
Okay, the request to change bond conditions or the bond is denied.
Can you be excused, Judge?
You may. Thank you. All right, anything else we need to take up? Everything else at 1:30? We'll see y'all then.
Yes, sir.
Mr. Vandenberg, come on up.